So welcome to the mergers panel. We had never dreamed, I suppose, when this symposium was originally scheduled that we would not have new merger guidelines by this time. So it changes the basic objective from one of critique to one of prediction. But I think we'll have just as much fun because we have a panel with an absurd amount of antitrust talent and experience. I'll get to that in a little more detail when I get to beginning the discussion. But you know, this is not my first rodeo when it comes to merger guidelines. I happen to be the Deputy Assistant Attorney General to Bill Baxter back in 1982. And things were so much simpler back then. I looked at the Department of Justice Antitrust Division directory for the front office, and boy, there are a lot of lawyers and other folks running around the Assistant Attorney General's office these days. Back in the Baxter days, we had 3 deputies and 3 special assistants, and Bill Baxter had 3 projects: merger guidelines, amicus intervention in private antitrust suits to help improve the law, and a review of ancient antitrust consent decrees that were still gumming up various industries. And he said he attached 1 deputy to each of those 3 projects and 1 special assistant to each of those 3 projects. And I lucked out. I got the merger guidelines one. But I can't really say I did the merger guidelines. Everybody knows that Baxter was the inspiration. I was a little bit more like a general contractor, I guess you could say. Most of the work was done by a real artiste by the name of Tyler Baker, who had worked with Bill at Stanford and clerked for Powell on the Supreme Court and spent the better part of a year drafting up the guidelines. And then we spent about 6 months going back and forth between various internal commenters on those guidelines, and voila, out they came in June of 1982. And back then, the major intellectual and analytical innovations of those guidelines were actually fairly straightforward. I think there was a pretty common understanding within the profession of what was needed. The first merger guidelines had been issued in 1968 by Don Turner and had sought to take maximum or nearly maximum advantage of the incredibly pro-government structural presumptions that were in the law at that time. And it was time to move to a more economically nuanced analysis of mergers. And so that's essentially what the 1982 guidelines did. And you had some presumptive thresholds based on HHIs rather than concentration ratios. And that essentially, along with some economic routines for thinking about barriers to entry, product differentiation, market definition, and other analytical issues, that pretty much set the tone for merger analysis, not only in the United States, but globally as antitrust law spread around the world in the 80s and 90s and since. So now the whole issue of concentration reared its head again in the about the year 2000, when the voices for a more aggressive antitrust enforcement policy once again started relying on the old notion that more concentration means more market power, and therefore mergers that increase concentration substantially should presumptively be stopped. But thanks to Kaye Ewing, who was then who actually was my predecessor in my office with Bill Baxter, and who was eventually a chair of the antitrust law section, he convened a task force, the Task Force on Fundamental Theory, to examine merger antitrust theory, and it included such luminaries as Tom Leary, a former FTC commissioner, and Michael Porter, the world-famous competitive strategy guy, as well as a smattering of other very outstanding antitrust economists and lawyers. I see Don Baker and Greg Worden and Jim Loftus and well, that's enough for one day. So they summarized, as you can see, this is a fairly weighty volume that you don't see in many offices these days, and I can't say I'm absolutely sure that it's on the internet. This was kind of in a transition when most people had AOL, but not much else. But anyway, Barry Harris, a very talented antitrust economist who worked with Bruce Owen at Economists Incorporated for a number of years and also had positions in the government, concluded as follows. He said, overall, the economics literature does not provide the basis for a merger enforcement policy based principally on concentration levels. Next, the results of the theoretical models are quite sensitive to each model's assumptions. And well, I won't go into that any more deeply, but let's say that Barry did a good job of summarizing the fact that all of the various papers included in the study compiled by this task force were advocating a much more nuanced approach, even relative to the 82 merger guidelines. And so it's been the kind of gospel that, concluding with the 2010 guidelines, concentration plays a role. It's maybe a good starting point to begin speaking about how to analyze the potential anti-competitive effects of a transaction, but it should never be the end of the story. There are a lot of more subtle issues that we've gotten pretty good at analyzing that now figure in. So imagine my surprise when the antitrust discussion began leading back toward the issue of concentration and merger control. The first warning shot, I guess, was the 2016 report of the Obama Council of Economic Advisors suggesting that concentration in American industry was rising, that barriers to entry were getting bigger, that companies in general were getting bigger margins and were more profitable, and tying this by implication to the idea that antitrust enforcement had kind of wandered off the path. Well, it didn't take long to go from that CEA report to an article in The Economist, and pretty soon just about every NGO in town, the Roosevelt Institute, the Open Markets Institute, and a bunch of academics and so forth, sort of made it a common refrain in the antitrust discussion that antitrust had lost its way, that merger enforcement had been lax, and that this had allowed concentration to emerge, and consumers and the economy were being harmed. So this particular guidelines project, announced in the simultaneously, as I recall, with President Biden's executive order on competition and the economy, and the launching of the consultation about what to do about the guidelines, done with great fanfare. Well, here we are. I guess it's a little more than a year later. There's been a tremendous number of submissions and to the agencies on what to do about their guidelines. Last week, I think it was, Assistant Attorney General Cantor was rather closely cross-examined about what the timing will be for the issuance of the guidelines, and he tried to make it sound like it would be soon, but at the same time he worked very hard to avoid making any commitment. Having seen this process from the inside, I can understand why he would want to kind of reserve his rights, particularly if it's intended that the agencies jointly issue guidelines, as they have been doing for the last 2 or 3 versions. But we're kind of hopeful, maybe there's a whiff of hope that more or less in accord with tradition, the agencies might release the new guidelines in conjunction with the vast spring meeting, the bacchanalia of the antitrust law section, which will occur in the last few days of March. So there is this is a very target-rich environment. Just any issue you can think of coming up with regard to antitrust analysis of mergers by the federal agencies is fair game here. And we've got this absolutely stunningly overqualified panel. Let me just, their biographies, their more complete biographies are in the material, so I'm not going to go into it at any length. But to my right is George Cary, a partner at Cleary Gottlieb. He has spent his life as an antitrust litigator, and a good part of it as a litigator for the Federal Trade Commission, but also as a litigator for various parties involved in deals subject to antitrust review. Then we come to Debbie Feinstein, who was a former head of the Bureau of Competition at the FTC, and therefore, in a sense, responsible as the chief prosecutor for a number of years. She's now the head of the Arnold and Porter Global Antitrust Group, as I understand it. And then we come to Michelle Yost Hale, who is a partner at Wilson, Sonsini, Goodrich, and Rosati. Also has a good career going in advice and representation to merging parties, and also spent time on the cross at the FTC, I believe part as a staff attorney and part as counselor to several directors of BC. Oh, including Debbie. Okay, thanks. That's news to me, but no harm there. That's great. And finally, on the far right there, not John Quokka, unfortunately, due to ice conditions up at Logan Airport. John Quokka is a professor at Northeastern and lives in Boston and couldn't quite make it down, even though he tried. But we figured, where can we find a solid academic antitrust economist who's been at the FTC, whose last name begins with Kaye? And so magically.
At 5 in the morning.
At 5, okay. I'm glad I was not the one who had to make that phone call. But anyway, so it's almost impossible to break down all the separate issues. So I'm just going to launch, and our first discussion is going to surround a number of ideas that have been propounded by the new progressives who are running the antitrust agencies and their supporters in the Congress and other parts of the Washington area about new theories of liability. We're looking for, where is this lax antitrust enforcement coming from? Is it that we have failed to prosecute things, failed to identify the types of deals that should be challenged? We all know that after many decades of merger enforcement, there has emerged a classic short list of theories of anti-competitive effect, coordinated effects, unilateral effects, and actual and potential perceived competition. And of course, we have vertical theories, which are much harder to classify, but they usually involve some variety of foreclosure, but there are many very exotic variants on that theory, like Archimedean leveraging. You remember that one? Okay. So, and so lately, what we're hearing from agency heads and the progressive NGOs, categories like nascent competitors, somehow different, I guess, from a potential competitor, killer acquisitions, and reverse killer acquisitions. So the question I want to pose first is, are these really new theories, or is this basically creative writing? And if there are some new valid theories of anti-competitive harm, will they fit within existing law? And to take a first stab at that, I'm going to pass the microphone to George.
Thank you, Ted. First, I want to thank the Global Antitrust Institute for inviting me and getting me out of those blizzard conditions in Los Angeles to balmy Washington, D.C. in the winter. I always learn something at these conferences, and today is no exception. Who knew that Tad Lipsky was in a rock band? That's quite remarkable. So are these new theories? I'm going to say they are not new theories if they are applied correctly. So if you want to go back, since you have, into history, and the theories that we're hearing about are nascent competitors. We're hearing about roll-ups, and that's a new theory where private equity will go out and buy up a bunch of competitors in a field, and there ought to be some antitrust prohibition of that. I guess I would say they're not a new theory unless you think pre-1960 is recent. I don't know. I mean, the roll-up theory, to me, sounds a lot like Vaughn's Groceries. The concern in Vaughn's Groceries was you had a pretty unconcentrated market, you had many competitors, but you saw a trend toward concentration that was the result of these serial acquisitions in local markets. And that ought to be stopped. And the Supreme Court said, yeah, that ought to be stopped. You gained 3% market share. You could increase concentration and create a problem. So I think the roll-up theory is not new. I think it's pretty darn old. Nascent competitions, I was hoping John Cuoco would be here, not because I don't love Bruce, but I think he was at the FTC when I brought a nascent competition case way back when. I'm not even going to say, well, I'll say the decade at least, in the 1980s, when I was a young staff lawyer at the FTC. The case was Schlumberger's acquisition of Accutest, challenged by the Federal Trade Commission. It got 4 votes on the commission, including 2 Republican votes. And the theory was that Schlumberger's Fairchild Cameron Instrument business, which was in the automatic test equipment field, testing semiconductor chips, particularly the most advanced chips, logic chips, had an installed base, a dominant share. I can't remember exactly, but it was in the 70-80% share. Hard to switch because you wrote these programs to test the most advanced chips, and you would have to redo your library to move somewhere else. There was a startup up in Boston called Accutest. They'd come up with a revolutionary new paradigm for testing these chips. Schlumberger went out to buy Accutest. Accutest was one of 3 or 4 startups, so not the only one. Schlumberger bought them. FTC sued. This was not a reportable transaction to break up the deal on the basis that the dominant firm with an installed base was buying up a nascent competitor who could challenge their dominant position. So not a new theory. Does it fit within existing law, though? That's a different question. And I would argue that it really depends upon how these theories are applied, whether the learning that has occurred since 1960 will be applied or 1980 will be applied. And Tad bragged about his own experience writing merger guidelines. I was there when the Clinton administration, Bob Potofsky, no slouch in antitrust enforcement, Bill Baer, not a slouch in antitrust enforcement, revised the guidelines. I was one of the principal authors of the guideline revision to include efficiencies in merger analysis. So that concept has been incorporated in the law. I think most recently in the T-Mobile Sprint case that I litigated up in New York, where the court found that efficiencies matter. If the law, which is based now on an economic understanding of competition, is applied, there are places for roll-up cases to be brought. There are places for nascent competition cases to be brought, but the right paradigm has to be applied and the facts have to support the theory. There are efficiencies that flow from roll-ups. There are local companies that might be consolidated, generating economies of scale, creating a national competitor. Those are going to be efficiencies that have to be factored in the analysis. Nascent competition. I look back on my own Schlumberger case and wonder whether we did the right thing, frankly. You had this installed base, high switching costs. They couldn't switch away. You had this great new technology. The quickest way, the most efficient way to get that technology to the semiconductor industry was to let the firm with the installed base acquire the technology and integrate it with its own IP-protected intellectual property, which overcame the barrier to to the use of that technology, which is the installed base problem. So these theories have a place, but they have to be looked at in the context of current law if they're going to be successful, in my view. And that incorporates the holistic view that was incorporated in the 98 guidelines. I'll stop there. I obviously have much more to say on the topic, but hear from others.
Anybody else want to make a comment?
I agree with George, which is amusing because the one time I most disagreed with him was on a nascent competition case that we brought that I think George thought was completely wrong on the facts. But the point of it is that we felt like under existing guidelines and merger precedent that we were prepared to bring a case, and that was. Acthar's acquisition of Synacthin, and that was a situation where the company acquiring it was, we thought, the dominant person, and there were two others interested in buying it, and there was a question about whether or not they could bring it to market. And if you look, there's a blog post on the FTC website that makes clear we weren't sure whether we could bring that under Section 7 because of the likelihood standard under Section 7, but we thought that it was a viable Section 2 theory. We'll never know. We never had the chance to litigate it. It got settled. I think the point I would make, though, is that we were bringing those cases. We were thinking about those cases, and so I agree that there's nothing new about that. Even in more recent, kind of post-'80s history, I don't want to suggest that there was this bright line that, as of sort of, 1960, all of these ideas were thrown out and not taken forward. They were, maybe in a different way, maybe cases weren't brought. And I agree with the point, too, that you have to think about potential competition, nascent competition kind of cases are tricky, and you always look at the one I think about is the Seba Sandoz Geigy case. I think it was that one, which was about developing gene therapy, and the case was brought, and it was a question of whether or not gene therapy was more likely to flourish if the merging parties hadn't combined, and it was brought. And of course, gene therapy didn't come to market for many years after that. And the question is always, would they have done a better job if they had been able to combine? And then the final case is the Genzyme-Novozyme case, which I commend to you reading the various statements on that. That was a consummated merger, which was the unusual case, and we represented the Genzyme in that case. And that was the unusual case of being able to see whether or not some of the efficiencies in terms of developing the product had actually come to fore. And Tim Uris wrote, I think, eloquently on the reasons why, even though it looked like a merger to monopoly, it was actually not a case to be challenged. We could debate the merits of all of these cases endlessly. The point I would make is that the agencies have been continuing to bring these cases for a very long time.
And when you say that Miras wrote about it, that was as a decision announcing that there would be no challenge, right? Yeah,
Correct.
okay. As distinct from his later academic role.
Sorry, I should have made that clear. He was chair at the time.
Okay. Did you want to comment?
Yeah, I guess I appreciate, Tad, your intro and your perspective on is this new or is this creative writing? And I think I want to go with the creative writing category. I kind of take umbrage with the notion that the antitrust regulators have been lax, having been a trial attorney at the FTC for a decade before I went into private practice, bringing many cases with many different types of theories. And so, we were constantly trying to push the boundaries, trying to examine potential competition in particular, which is something that, I think my first case with Debbie, we examined that very closely. And I think as the agencies have realized in the past couple of years, it's really hard to bring a case and it's really hard to win a case. You have to have evidence. And so there's this kind of false notion that, is this just based on a presumption? Is this just based on concentration metrics? Really, when you bring a case, you have to have all of the legs of the stool or you're not going to win. And you can look at any of the agency's recent losses and see kind of where the evidence didn't line up to the theory of harm.
Okay, I did a lot of preparation for this panel since fine. On roll-ups, I mean, when I was at BE, there were some vertical transactions. So the one I remember, and I think somebody in this room was the expert. But yeah, I agree with Michelle. Like, you know, they brought in evidence about. So it was a health insurer buying up doctors' practices, and you know they started off. They bought a few, and then they vertically integrated. And at some point, you know, what you do is just a standard diversion analysis on sort of, you know, how much do they have and what's going to be the strength of the RRC, and the parties brought in evidence, and yeah, it's really just an evidentiary based inquiry. And you know, if it's a new theory, it's not really new. It's, you know, at least decades and decades old, and it's just maybe not used that much. Nobody talked about killer acquisitions. I mean, there's actually, I think, a really nice, well-done paper. I say Florian Eder because he's the one who I saw present it twice, but he has a bunch of co-authors, and it's about pharma acquisitions. And, you know, I mean, it's a really detailed sort of look at whether or not, you know, acquisitions at stage one then sort of suppresses on the margin, you know, whether a drug proceeds to stage two. It's really carefully done. It took them, you know, a lot of time to sort of go through the available data. And, you know, it's one of those, why did they study this? Because, you know, it's the economists under the lamppost joke. You know, they had really good data. But you look, and they're really careful, and they say, I don't know, you know, this is not the external validity of this. I don't know if it applies in another industry. So, you know, I do think, you know, it is, there are these theories, they're not new theories, but they haven't been brought because they are often, you know, hard cases. I mean, all these cases, Genzyme, Nozyme, they're all innovation cases. And you have to do not just the prediction like a guppy, but you have to do some prediction about the future and innovation, and you really don't. Really, I mean, I don't know. You could flip a coin and probably do better.
Let me, before we get off of this topic, I wanted to throw out the question of one of my favorite transactions, Illumina Grail. And there's a lot to talk about, and frankly, a lot that could be just kind of divert us from the main chance here. But I guess what concerned me the most from the perspective of predicting what the guidelines might say, that if, and I'm assuming they will, address vertical, I guess maybe I shouldn't assume. Maybe that's an independent question, whether we expect vertical guidelines. But I read the complaint almost as saying that if you're a company with a unique resource, you cannot integrate downstream. It was almost a per se case because it basically said, look, you're going to have this marvelous new technology, DNA analysis technology, and if you buy up somebody who uses that technology, in this specific case, Grail was creating this wonderful blood test for, you know, to predict cancer or detect cancers. You can't do that because you might provide your technology to competitors of the downstream entity at less favorable prices and terms than you supply to your own internal entity, and that's bad. And that struck me as pretty much a theory you could apply to any vertical merger. So where am I wrong there?
Well, first disclosure, our firm represents Illumina in that matter, so take whatever I say in light of that. But I would say the following. I would say that if you look at the original complaint and if you look at the original trial brief and opening argument in that case, I mean, that complaint did get 2 Republican votes. It was a credible theory. It was not a theory that was outrageous. The issue of this burden of proof is obviously always in play, but the problem with that case, as it turned out, according to the administrative law judge, is that the facts did not support the theory that the government put out there. The fact of others that might come in with competing technologies, fact as the FTC had styled it, turned out to be kind of speculation or wishful thinking. The evidence did not support that there were people there ready to compete with Grail. That's number one. Number two, I mean, interestingly enough, Grail was owned by Illumina. Illumina developed that technology in-house, spun off some of it as a financing mechanism, and then tried to reacquire it. So I think that's a relevant fact. But I think the key to that case is essentially that the judge was faced with a choice. Do I accept the notion of accelerating the pace of that technology and saving lives now at the expense of some possible effect 5-10 years from now, according to the record? Or do I block the deal? Do I prevent customers, patients from getting that technology immediately and in bigger numbers and more effectively in the hope that someday somebody will come along who might have been discouraged by virtue of this vertical relationship? Bottom line is that you don't bring cases to make a point. You make a point by bringing the right cases and having the courts sustain demonstrated anti-competitive harm. And I think that was the problem in that case.
Well said.
So I guess one kind of counterpoint to that, George, is that Illumina's short read technology is so incredibly entrenched in the genomics space that it would be hard if they acquired a technology that was as disruptive as Grail was predicted to be for any other technology to then unseat Grail, right? And there's unlikely to be a technology that unseats Illumina's short read technology. And because Grail runs on the short read sequencer, it's necessary for that technology to kind of be open to the market, and it's the incentive to foreclose. But I take your point, it is very hard to prove with evidence harm from a vertical theory. And what the agencies have going for them is that they're able to bring these cases, and oftentimes they're abandoned. Look at Lockheed Aerojet, for example. And if you contrast Illumina Grail with where you also had, Illumina had also made a commitment to hold constant all of the factors and support other providers that would compete with Grail. So there was an open commitment for potential competitors to Grail, right? Here in United Health, a case that was actually litigated in a vertical theory of harm, there was a similar kind of litigation of the fix issue that I think DOJ didn't really focus on quite as much as maybe they should have in hindsight. And the court there found, yeah, United, we hear you about these incentives, but we are looking at the testimony of these United executives, and we don't believe that that's what's going to happen. We don't believe that this incentive to foreclose is really going to come to bear, and found in favor of the parties. So I guess kind of two things. When the cases get actually litigated, things don't tend to always go the agency's way, which seems to be my theme today, which wasn't the plan. But also that, the agencies have a tremendous amount of power to bring cases that are based on these novel theories of harm, if we want to call them that, and thwart the potential for the efficiencies to be achieved from the transaction. Not that I'm harboring sour grapes, but I represented PacBio in Illumina's failed acquisition of PacBio, and I'm still waiting for my PacBio short read sequencer and for my Illumina long read sequencer. Many years later, I also represented Plaid in DOJ's challenge of Visa Plaid, and I'm still waiting for my Plaid debit card. So I think it remains to be seen where the evidence would have come out in those cases that unfortunately I didn't have the opportunity to litigate, but the fact that those things aren't on the market today is indicative of maybe the lack of strength of the agency's cases.
So on that note, real quick, just because you brought up the case, we're still also waiting for the new Athcar replacement therapy to come out of the Mallinckrodt deal.
So, Illumina PacBio, Actually, the funny story is my going away party was conflicted with the commission meeting for Illumina, PacBio, and the body cam, Axon. So I missed my going away party. And people said I did that on purpose, but it's not true.
That's not the choice I would have made.
Yeah. So Tim and I actually wrote a piece on Illumina Grail. And just sort of going back to the theme that it's hard, but it's not novel, right? I mean, you could do that case, except that the diversions from the RRC were, we called it imaginary and future diversions, right? The market wasn't even, I mean, there were some people who had limited use of the Grail test, and it was $1,000. And you had to be, really at risk for, generalized risk of cancer to pay that much money. But, normally what you do, in a cable merger, buying, AT&T, Time Warner, and what Carl did in that merger was, you do an analysis where you say, okay, here's the RC incentives, and here's any EDM incentives. And in Illumina PacBio, you can measure what those were going to be. I mean, they were taking a margin. They had an agreement that they had some percentage of their revenues. And so, it is, not just deaths now versus deaths later, but, you could actually do a traditional, here's the, and EDM's not an efficiency. I always say that. It's a unilateral pricing effect. You do that unilateral pricing effect against diversions 10 years down the road, maybe. Right? And you don't know how big the diversions are because somebody could come up with a differentiated test that there's not a lot of diversion between the two tests. And so, it got 2 Republican votes, and, Christine is going to quit, so I guess I could finally ask her right now.
Debbie, did you want to contribute in this? Or should,
No,
okay,
I want
let's
to move on. I'm not
all
going to
right.
get in the middle of the aluminum.
All right,
rail.
yeah, we got into that. Okay. All right. So next topic: market definition. Now, the role and the character and the techniques of market definition have always been very active and lively subjects in merger review. There was a rough and ready approach to market definition that was already contained way back in Brown Shoe in the 1968 guidelines. And the 68 guidelines, of course, were written by Don Turner, who was a PhD economist, so he was paying some attention to that. But much greater care was taken on that specific issue when Bill Baxter, introduced the hypothetical monopolist test. I think there's some evidence that it had been kind of in circulation prior to that, but clearly the 82 guidelines embraced the hypothetical monopolist test. As Baxter was fond of saying, I'd much rather have a very fuzzy answer to the correct question rather than an answer to 6 significant digits of to the wrong question. So that was the hypothetical monopolist test. And that approach, it's stuck, and it's become really the world standard. It's been accepted by the judiciary and the antitrust agencies of many, many countries around the world. But now we're hearing new concepts relevant to market definition, like stacks and clusters and such like. And we're worried about whether those should be employed, especially in new technology spaces where there's some novel and subtle relationships among different things in the product space. So I'd like to pass the mic to Debbie to ask what issues are these new approaches intended to address, and do you think the new approaches that are likely to come out in the new guidelines will have any real utility?
Oh, I am just going to vehemently disagree that these are new approaches. I think that everyone who's in the antitrust world should read Brown Shoe at least once a year. It is fascinating, and it is still good law. It has all of these concepts that we're talking about in market definition today, other than maybe targeted customers, which I'll talk about in it. So I think that we've pretty much got market definition well covered between Brown Shoe and the HMT, and I don't see either of those going away anytime soon. Now, look, brown shoe can be a little fuzzy, right? There's a list of factors, and they're often not going to all point in one direction. And I remember in the Staples 2 case, the defense lawyers were questioning Carl Shapiro about a cluster market theory, which I'll talk about in a minute, but basically hammering him on the fact that, well, people in the industry don't think about the way, markets the way you do. And Carl just sort of smiled and said, well, you see, the word market is very special to me, and explained from an economist's perspective how you ought to think about the markets to a judge who I think was initially quite skeptical and then came around to it. One of the questions that we hear, and this is again not new, do we have to define markets? Is it necessary to define markets? I got to tell you, I never found it particularly a problem to have to define markets when I was bringing cases at the FTC. I think most people say that Section 7 requires it, and we didn't spend a whole lot of time worrying about it. The only time I ever got a little frustrated on market definition was coming up with the right geographic market definition in hospital cases, when you knew that the diversions were there, but then you had to figure out which hospitals are in and out, and how am I going to articulate it carefully. That didn't stop us from being successful in every hospital merger we brought during the time that I was there. So even that was manageable. Okay, so what about the guidelines should be changed on market definition? I think there are a couple of things that, and I was there for the 92 guidelines revision, at least for a good chunk of it. And if I knew that I was going to be bureau director and had in my head all the things that I wanted to do, I would have written the guidelines differently. Because there's just a lot that I don't think that they explain quite as well as they could. The words cluster and bundle are not, I don't think they're in the merger guidelines, but they're certainly not spelled out in a way that I think would make it as helpful as we could have been. We spent an inordinate amount of time in Staples 2 explaining the concept of a cluster market that, frankly, we shouldn't have had to. It was pretty, it's there in Brown Shoe. Brown Shoe basically talks about cluster markets, combining men's shoes, women's shoes, kids' shoes when the competitive conditions are the same. And that's the simplicity of a cluster market. And we spent a lot of time with the defense lawyer saying, but you removed ink and toner because the market shares were different. Yes. It felt like, but then the market shares would be lower if you included ink and toner. Right, that's why we excluded it. It felt like one of those Abbott and Costello routines. Who's on first? Yes, we're agreeing with you. That is exactly the reason, and that's exactly the point of a cluster market is rather than basically bringing a case, which we could have, about the sale of pens to B2B customers and then the sale of Post-it notes to B2B customers. We said, look, for this broad category of stuff, it's all the same. That's a cluster market. It's a pretty simple concept, and I thought Brown Shoe handled it pretty well. Bundles are a different issue. You could call them bundles. Stacks is not a phrase that I've heard used a lot, but I think it's the same as...
expunge that.
It's fine,
Debbie,
it's fine.
sorry.
I'm just saying that some people talk about stacks. Bundles are, the concept, but that's when you're buying a group of things together, sort of a one-stop shopping issue. And I think that supermarket cases are sometimes talked about as bundled market. I think you could also talk a lot of supermarket cases as cluster markets because the competitive conditions for the sale of bananas in a grocery store are probably similar to the competitive conditions for the sale of cereal in a supermarket. If you believe that people are going into a supermarket because it's different than buying a box of cereal at the drugstore, I think if the merger guidelines to take it to the next level, I think better articulations of when you use cluster markets, of when you use bundled markets, what the differences are, what the kinds of features that you ought to look at are, answering some of the harder questions. And I think the questions are much harder for bundles than they are for clusters. So if you're talking about supermarkets, how many SKUs do you have to be in the market? What's the appropriate bundle that we're talking about? If people are buying small bundles, what does that tell you? If they cross-shop, what does that tell you? All of those kinds of questions in terms of what the right way to look at the bundle is. Does the fact that there is a bundle mean that people never buy unbundled? How much of a constraint is there from unbundled stuff on a bundle? All of those are really good questions. And then the final thing that I think I would do if I got a chance at a pen with the merger guidelines is really think about better articulating the role of targeted customers and how you think about that. Carl said that they put that in front of market definition on purpose because he sort of thought of that as something separate. But I have to tell you, courts think about it as part of the market definition, and articulating how you ought to think about that and how that relates to market definition even further. I think now that there's some case law developed on that, explaining that would be really useful. So without blowing up HMT, without throwing brown shoe out, I still think there's a lot that you can do to even better articulate how you might think about market definition in a way that would be useful.
Thank you, Debbie. Anybody else want to respond to that or extend?
I'd
or-
like to respond.
Okay.
So Debbie, I disagree with you, amazingly enough. I love the Bill Baxter quote, which I'd never heard before.
Oh, okay.
But I think maybe it's not completely apropos here, because it seems to me that the fuzziness is in the brown shoe factors. You've got these random factors, are they the same sellers? Are there different characteristics, whatever the hell that means? I mean, you got all these different factors, and you assemble a set of them for the particular circumstances that you're confronting, and you go into a court and you say, these 3 factors are the same and therefore it's a market, or these 5 are the same, these 2 are different, but it's still a market. That's the fuzziness to me. It seems to me that merger law in particular needs to have an intellectual hook. I think Dennis said earlier that without it, you basically get any result an enforcer wants to get at. Cluster markets, bundle markets are no different than any other product market if you're using the hypothetical monopoly test. So the reason that a cluster can be a market is because it is more efficient to provide the cluster than it is to provide the products separately, presumably. And to the extent that there are firms that do that, and to the extent that it can be shown that if those firms create a monopoly, they could raise prices on that cluster due to those efficiencies, then you got a market. And you don't need to, rearrange the 7 or 9 brown shoe factors to get there. I think I do agree with Debbie that the brown shoe factors still are relevant and important when you get to court. But using the Staples analogy, since she brought it up, I'll use it too. I think the way to go about it is to show the economic reality. Here is why this cluster of products sold by these sellers is going to have an effect if you have a merger amongst them that increases concentration. And then you use that to back into the brown shoe factor. You use that to show that the particular factors are relevant and important in this case in order to establish the legal threshold. So I guess if I have one theme for the day, it is regardless of how aggressively you want to assert the burden of proof, regardless of how lax you want to make the burden of proof, deviating from the economic lodestar, if you will, in defining these terms is where the error gets introduced that actually hurts consumers.
One thing, then I want other panelists to jump in. Look, I don't disagree. I think there's some fuzziness to brown shoe, but I think when used properly and in conjunction with the HMT, I think it can be very useful. And unfortunately, the HMT is not this magic formula that everybody agrees to. It is not 2 + 2 = 4. And we spent an inordinate amount of time in the Cisco case arguing about the HMT to the point where the judge finally said, look, I cannot figure out whether the right denominator for the aggregate diversion test is the formula that Carl Shapiro and Joe Farrell had in their paper, or the one that I can't remember ever if it's the Norwegians or the Swedes had in their paper. He's like, that's not something I can do, is figure out which the right way is to do this, but I'm going to hear what the economists have to say about all the factors and look at it. And so HMT was a part of it. We're not at a world, this is not CSI of merger economics where we can do it. So the question is not to tally up the factors, but to look at the totality of the evidence. I think the HMT is super important, but it's not by itself, I think, ever going to be the end of the inquiry or persuade judges.
Did anyone suggest, what is it, Rule 703, that the court could hire its own expert?
Yeah, that's the worst of all worlds.
Anyone else want to take this on?
Michelle?
I just one funny thing, as Debbie was talking about Staples too. So the very counsel for Staples and Office Depot criticizing the cluster market approach had previously worked at the FTC and agonized over defining a cluster market in ProMedica St. Luke's, where the competitive conditions for OB services between those hospitals was different, and whether it was appropriate to include them in the cluster or to allege a separate product market. So it was ironic and coming back full circle to be at the FTC at that time when we were bringing the second Staples case, not to be confused with the first Staples case, which is George's case.
Yeah, I mean, economists, actually, the guy worked for Joe Simons and Barry Harris did critical loss, and Farrell and Shapiro and Wickelburn and O'Brien did the learner-based, aggregate diversion-based critical loss. And so, there are advances. It's not a formulaic thing. It's trying to look at sort of a firm-based way of looking at sort of whether people have the right incentives if they were a hypothetical monopolist to raise prices. And so, I think that economists have made strides. They've been incorporated into the guidelines. If you're right there on the margin, then, the Swedes versus Carl Shapiro is going to matter, but generally it doesn't. There's a camp, I guess Louis Kaplan is the most famous person who says this. It's like, let's just get rid of it. Let's just do effects. But, the Farrell, Shapiro, Wickelgren, O'Brien aggregate diversion approach is really trying to sort of, make it consistent with, the unilateral effects analysis. And so, I think to the extent you think that's a good thing, that's what economists have brought to it. And it's done a lot, to deal with the fuzziness of brown shoe. I mean, under brown shoe, you had, things like Continental Can, Atlas Glass, where, the court just made up stuff that, and so, and you look at within Meta, right? I mean, one of the experts tried to do a critical loss analysis and I guess did it really badly. But, how did the judge do market definition? He used the brown shoe factors, and so in that sense, I agree. When you go to court, a lot of this post-1950 Act merger law is still the law of the land.
That's a great point. As a matter of fact, if you're not inside baseball on this and you want to learn a hell of a lot about current merger analysis by reading the minimal amount, read the district court decision in Meta within. It's a judge that I had not previously identified as antitrust savvy, but he just goes through it. You'd think that a PhD economist who had worked at the antitrust division of the FTC for 5 years had written the opinion. I thought it was quite impressive. Anyway, just a practice note for you there. Let me move along. I think this whole question of how market definition is treated, we've ended on a note that makes a good segue to a more general topic that I'm going to toss to Michelle for initial comments. And that is, of the significant innovations in the new guidelines that have kind of been signaled, but unfortunately have not yet been asserted by the new administration, how is the federal judiciary going to receive some of these innovations? From about 1940 till about 1973, antitrust was tilted very heavily toward per se rules and very strong presumptions of illegality. You had Philly Bank, and then the shares that it kept getting applied to were lower and lower and lower. So you ended up with Vons and Pabst and all the rest of them. And so this approach was used to condemn mergers. But then, all of a sudden, reflecting perhaps a change in the composition of the court and also an evolution of the analytical environment, you had the Supreme Court deciding General Dynamics and Marine Bank Corporation, both in 1974, two merger cases where the government's complaint was rejected based on some kind, what we would recognize as economic reasoning. I'm not going to go into it because it's kind of complicated. But the question is, are we really at a similar junction point in antitrust? Has there been this ferment leading to a shift in the consensus about what antitrust and merger analysis needs to be concerned about? And will courts be persuaded that the last 49 years have been a, quote, failed experiment, which is the way that President Biden actually referred to the last period of antitrust enforcement? And will the courts just shift to adopting the kinds of progressive views that we expect to be reflected in the guidelines? So that's an easy question, Michelle.
So I want to
Knock it out of the park.
I want to thank Tad for giving me homework and making me read cases that I haven't read since law school. So just to kind of, as I read through Vons, Pabst, General Dynamics, and Marine, I saw some themes that I thought were kind of really interesting. And the short answer to the question is no. I don't think the courts are going to see the work that the federal judiciary has done in antitrust over the past many years as all for naught. But to kind of take a step back, so it's interesting to see kind of the tools that the agencies use to bring these cases and how they've evolved over time, and that was something that really struck me as I was looking back through these old cases. So in Vons, there was a local chain of grocery stores in LA wanting to merge with another local chain. They would have then become the second largest grocer in LA. But the overall market share for retail grocery sales post-merger was 7.5% of the combined firm. This was at a time when many grocery stores were consolidating, many mom and pops were abandoning their efforts and selling to corporations, and there was a general trend of concentration. And the court was really concerned about that. The court held that Section 7 requires not merely an appraisal of the immediate impacts of the merger upon competition, but a prediction of its impact upon competitive conditions in the future. And we're all in the business of predicting the future up here. I mean, that's the hard part of our job. It's particularly hard right now with a lot of guidance being withdrawn from the agencies, trying to understand where the agencies are going to come out and trying to predict in any given merger when you're advising a client what the agencies are likely to think, given so much of this has been politicized and doesn't seem to be necessarily grounded in a principled guidelines approach or the recent withdrawal of the healthcare statement by DOJ is another kind of troubling trend, and smacks in the face of what I prided myself on as a trial attorney at the FTC, which was government transparency and being open with the parties and explaining the theories of harm and what we were finding in the evidence, and kind of working every step of the way together, even if we disagreed on the ultimate conclusion. So another thing that struck me about Vons that was really interesting is how refined market definition has become. Debbie was talking about proving the market in Cisco and proving the market in Staples and our hospital cases. I mean, we worked really hard to prove those markets, and the market definition has to sing with the competitive effects. They have to go hand in hand, and if they don't, you've got a problem, you're doing it wrong. And that's something that staff takes very seriously when they bring cases, and I don't really see, even though there are all these kind of novel theories and concepts kicking around, I don't really see that changing, and that's still what you're going to have to do to bring cases. In Pabst, again, you had this strange combined market share of around 5% of total industry sales between Pabst and Blatz Brewing Company. The government there alleged that there would be a substantial lessening of competition in the sale of beer in the US, in Wisconsin, and within the 3-state area between Wisconsin, Illinois, and Michigan. The court found for the government and also found that you didn't have to define with precision the metes and bounds of the geographic market. It was enough that, that in making the prediction that the government had proven that there was likely to be harm. And similar to Vaughn's, the court also observed a trend of concentration in the industry, which was factoring into its analysis. I think we, as this panel has said, we see that, particularly the focus on private equity firms and roll-up transactions, we kind of see that same theme today. It's not really that different. And then you see the law evolve. So in General Dynamics, which I would assume many in this room are much more familiar with than Pabst and Vaughn's, but that was the case where a coal producer purchased another coal producer, though they kind of did different types of coal extraction. And the court found that the acquisition did not violate Section 7. So there, what the court focused on was that United Electric's, the firm that was to be acquired, coal reserves were so low that its potential to compete with other producers in the future was far weaker than the kind of aggregate production statistics that the government was putting forward. And that all of its reserves were committed in long-term contracts, and so its power to affect competition in the future was diminished as a consequence. The possibility that at some point in the future United Electric could become more competitive wasn't enough for the court. And really, I think where that fell apart was, again, on the lack of evidence, which is something that I keep harping on up here as a litigator who hasn't gotten to litigate in quite some time. And then, so going on to Marine, here, again, a proposed merger between two commercial banks. We had, the NBC was a large national chain, but did not have a presence in Spokane, Washington. The target was Washington Trust Bank and was in Spokane. The government argued that absent the acquisition, NBC would enter the Spokane banking market. And that sounds very familiar, kind of like Meta Within, right? The court held that the acquisition there did not violate Section 7. Again, the geographic market, it was a lack of evidence. The government didn't show that the effect of the merger on a statewide basis would show a lack of substantial lessening of competition. And the other important factor there was that the competition was impeded by bank regulations. So that was another kind of factor that was playing into the competition and the dynamics in that market that the court found to be very compelling. If you look at the DOJ's recent loss in the sugar case, they similarly found that where the government could regulate the price of sugar, there wasn't necessarily going to be any problem. Didn't help there that the government witness that DOJ put up wasn't necessarily even supportive of blocking the merger. Again, a lack of evidence. So are we at that critical junction today? Are things really going to change? I think at the margins, when you bring cases that don't fit into a perfect rubric and aren't a slam dunk, the law is always going to change, right? Even in the loss on Meta Within, the court there did endorse a theory of perceived potential competition and did endorse these, what I found to be kind of crazy market definitions. And so while the FTC ultimately lost that case, it still pushes the margins and gives them the ability to use those tools, in the next case that they bring. I was going to talk about Illumina Grail, but we've already talked about that. And I've already managed to mention the sugar case as well, which is another case I was going to mention. But I think if you look at the trends through the cases that Tad outlined, and if you look at the current kind of thinking on how the merger guidelines should be refined, you'll see in the current cases a lot of corollaries to both very old cases and to kind of the current thinking that is going on at the agencies. And that might be the best guidance that we have right now when all of us are sitting up here trying to advise our clients on what mergers they should try and not try.
Thank you. Any response, comments?
I'll answer your question. The question, I guess, that I understood you to be asking is whether we can expect another paradigm shift.
Yes.
And I think I'm going to answer that no. The major paradigm shift that occurred through the cases that Michelle has described is the courts coming to grips with the fact that other than saying no, they had no rule of decision in merger cases. Because the standard was a substantial lessening of competition. Anytime you have a horizontal merger, you have a reduction in competition. And the courts couldn't quite figure out what the word substantial meant, and so they said no. What happened, and I'm not even sure it was General Dynamics necessarily, but I think it was Sylvania. What happened with Sylvania was that the court said, we need to rethink what we mean by competition, and we need to figure out a standard. And they shifted from a standard which said it's all about the number of competitors to a standard that said it's about the intensity of competition. And that evolved then into the consumer welfare standard. Will the transaction make the company more efficient such that it can compete more effectively with other companies and benefit consumers? Consumers then became the lodestar. So really, I hear your question to be, is there going to be a shift away from consumer focus? Is there going to be a move away from looking at the intensity of competition and back to something like counting the number of competitors or protecting competitors as a goal of the antitrust laws? I think with where the courts have evolved, going back to something that they will have a hard time articulating a rule of law around, I'm going to say no. Again, I think they might play with burdens of proof. They might play with what has to be shown, but I don't think they're going to go back to a protect competitors or an ambiguous standard.
Yeah, I think the courts have gotten too used to the storytelling aspect of competitive effects. I remember when I first got to the FTC, Josh Wright asked me, maybe in jest, maybe not, would I commit to not citing the Philadelphia National Bank burden shifting? And I said I would not commit to never citing Philadelphia National Bank, but I promised that the longer section of our briefs and complaints would always be on the competitive effects. That was about as good as he was going to get from me. But the point is, if you look at the opinions, the competitive effects sections are always longer in decisions than just the concentration. They sort of move on and, okay, yes, you've checked a box, you haven't checked a box, but they really want to understand, and they really spend a lot of time thinking about the competitive effects. And I think every time I've worried that we were going to lose a case, I would think, well, wait a minute, no, but the precedents and case law are good. Judges are going to read other cases, and I think judges are going to have a hard time. The judge who gets a merger case for the first time and looks at the recent case law, and by recent I mean last 30, 40 years of case law, is going to see this competitive effects element, and I think is going to be a little nervous about just stopping at concentration. concentration and saying that ends the ballgame.
Yeah, I mean, the problem is that it's so hard to get into court, right? I mean, they do, but I mean, I think what the plan of the current leadership of at least the FTC is to, just have within the court, I mean, Lena Khan had her Fordham speech, and she said, fidelity to law, and that meant, these cases where, Justice Douglas said the only consistency is the government always wins. And I agree with George that I don't think the federal courts are going to overturn it, but they're planning on, unless you do the Smarter Act and you allow, better access to the courts when you go through the FTC, I think they're just going to say, look, people are just going to give up, and we are going to do sort of, Vaughn's Grocery, or perhaps, because that is the regime of complete discretion within the agency. Yeah. And so within the agency, I mean, within the agency, I don't think, people didn't do Philadelphia National Bank. When I saw memos, they didn't have Herfindahl's in it on the econ side. And I think they were going to change that dynamic within the agency, and then I think it's going to be a serious change.
You mean eliminate Bureau of Economics memos?
Yeah.
I've heard questions about how much the economists have sway in this agency. I don't know. I've heard questions about that. I would agree. We did not see HHIs. It was all about what is the competitive effects. I'm saying when we got to court, Philadelphia National Bank was still relevant.
Yeah.
Well, our time is beginning to dwindle, and Bruce, I know that you have been studying for a long time, but given your history here and your familiarity with the issues, do you want to take just a minute or two and give a broad reaction to what we expect to happen with the new guidelines, and tell us your hopes and fears?
Yeah, I have no fears. I think it's clear what's going to happen. I mean, they're very transparent about what they want to do. I mean, we don't really know for sure, but they want to go back to the fidelity of the post-50 Amendments law, and that is Philadelphia National Bank, Vaughn's, Pabst, and Brown Shoe. And I think they want discretion. Michelle kept going evidence. They cite evidence, and the evidence they cite are the evidence that was used when they passed the Seller-Kefauver or Kefauver-Harris, or I know Estes Kefauver is there somewhere, the 1950 amendments. That evidence was a 1948 study by the FTC economists on the growing danger of growing concentration. And this wasn't, Dennis mentioned, we don't do regressions where we put price or margins on the left-hand side and HHA on the right-hand side. These were just assertions that there had been a dangerous trend in concentration. And by the time they were debating whether to pass the 1950 Act, that study had been debunked. And Cicilline cites it, Lena Khan cites it, as if it was still good. The modern stuff is the stuff that Dennis said, IO economists don't do that anymore because we've realized the problematic nature of it. Nate Miller wrote this fantastic article that he and Fiona Scott Morton asked a whole bunch of people to sign, including a bunch of former bureau directors and DAGs at the two agencies. And, I think the last 7 of the FTC bureau directors signed it, and it's a really diverse group, and Aviv signed it too, so the current guy signed it too. But I think that they don't have much evidence. Joe Biden could sort of assert that there's been a 40-year failed experiment, and they could say that there's growing concentration, and they could say, but if you really look at it, that evidence is not there. Josh Wright and Jen Favre have a terrific article. Tim Mears and I I think it came out yesterday, had a CEI piece talking about the evidence. And their evidence for their assertions are just not there.
I think we've reached question time if you want to take advantage of it. Fire away.
So I just wonder, I know you were somewhat dismissive of the role of concentration in the analysis, but that seems to be like an obvious place where they can revise the guidelines and revise the numbers downward. I just wonder if you think that'll happen, and whether, if it does happen, whether it will be meaningful either to parties, right, or internally, right? Just again as a as a screen.
Oh, I think it will happen. I'm not diminishing the importance of concentration. I think that I don't think courts will just instantly go for that if there's not also a competitive effects story that can be told with the evidence. But I think the concentration numbers will change. I think people are already assuming that. I think that the rhetoric out there has, first of all, I don't, in most of my cases, sit there and spend a lot of time looking at concentration numbers and saying, oh, you're above or below the HHI numbers. You get a feel for the whole case and whether it's the kind of thing that the agencies should bring. And given the rhetoric about looking at cases at lower concentration numbers, I think that people are already advising their clients that way.
Hi, this is Alana Kowarski from MLEX. My question is, are there certain theories of harm that DOJ and FTC officials have been emphasizing and that we think maybe in the guidelines that you think might have a higher chance of being held up in court? And are there some that you think have a lower chance of, being accepted by judges?
I'll take a shot at that. I think it goes back to what Debbie was saying and what I was saying previously, which is that it has to be tied to a story, an explanation. I think judges are not academic scholars, notwithstanding the observation about the meta-judge. They want to know the facts. They want to know whether there's a plausible case to be made that the transaction before them is going to hurt consumers, or more recently, looking at whether it might help consumers, which ultimately I think is what drove the Illumina Grail case. So case selection, I think, is really important. If one wanted to take on a really pro-enforcement, aggressive stance, one could do that in the way that Carl Shapiro did it, by tying it to the economic analysis and showing how specific facts work with the economic analysis, as he did in the most recent set of guidelines. I think moving away from that and bringing cases that theoretically look good but are not tied to the story of competitive effects as Debbie described it, I think that's where they're going to lose, and in so doing, will actually set back antitrust enforcement. So case selection based upon the facts of the case is the way to advance more aggressive antitrust enforcement, not simply to announce a principle and bring a case as a matter of per se.
Again, I think the guidelines will talk about these things: nascent competition, potential competition, killer acquisitions, put whatever label you want. It's not new. These are all, I gave a whole speech where I think the first 15 minutes was just trying to deal with the terminology issues, future competition, potential competition, nascent competition, talking about what that meant. I don't think these are new concepts, and I think, as everyone on the panel has been saying, it comes down to the economics and the evidence in terms of whether or not it's a good story. But these are all things that we've been telling our clients to look out for and we've all been thinking about for years. The one thing I think is new is the focus on employment issues, and monopsony employment issues is a newer thing. It's not an invention of this administration. Joe Simons and Bruce Hoffman. Joe brought a monopsony case when he was a young lawyer. I think Joe, was at the commission 3 times. I think it was his first time as a lawyer. He was deeply enmeshed in a monopsony case, and I think that stuck with him fairly. And so he's been thinking about monopsony issues maybe a little bit more on average than others. But they were all talking about whether or not a merger could have a monopsony effect on employment back then. So again, I don't think that's new, and it's just a question of, do the facts merit it?